Thank you. Thank you, Mr. Chairman. Mr. Wu, do you think that in American history, state court criminal justice processes have ever been perverted or corrupted for political objectives to affect matters of federal politics, such as the course of legislation or the composition of Congress or the control of the presidency?
I'm not sure of a specific instance like that. I mean, I think there has been a general feeling that some of the state court processes have been unfair or biased, and that was, for example, a reason for some of the civil rights legislation.
Sure, yeah, like even in the post-Civil War era, right?
Sure.
So I think I have distinct images of that having occurred, and processes that appear to be ordinary can be used to political effect in such cases, right?
Sure.
Even in totalitarian regimes, totalitarian systems of government, that's a favorite tactic, isn't it? The show trial.
Indeed it is.
Is there a legitimate federal government interest in preventing that where it occurs?
Well, there's some jurisdictional limits on what the federal government can do there. I mean, if it's a state trial, they'd have to come in after the fact to examine whether there's been some...
Well, let me ask you this way. Was there a legitimate federal interest when Congress acted, as we just made reference to, in the post-Civil War Civil Rights Acts?
Yes, those legislative...
And they were designed to prevent that kind of misuse, right?
I don't know that they were designed specifically at the court system misuse, but I think they were designed to correct injustices.
You don't think they were designed to correct misuses and abuses of the court system, the state court system?
No, that's not what I said. It includes
so you
that,
do,
but
you would agree with me that they were designed for that very purpose,
not
right, sir?
only for that purpose.
Yeah, I certainly agree. It wasn't only for that purpose, but it was included. How should Congress identify the misuse of state court procedures where it is happening?
Certainly, they can do investigations, hold hearings, but they should be after the fact of prosecutions, not during the prosecutions.
Oh. So let me just ask you a couple. Would evidence of that include overt public vows by candidates for prosecutorial office to target a candidate or prospective candidate for federal office?
That's certainly something that can be part of the fact-finding, yes.
What about the institution of charges for transparent political motivations, especially in the sense that the event charged is not regularly or ever charged against others engaged in similar conduct? Would that be possible evidence of such a problem?
It's a little bit tougher because the prosecutorial discretion wall is pretty thick on that, but it's certainly something that could be inquired into.
How about state legislative renewal of expired statutes of limitations aimed at such a political target? Would that be possibly evidence of such conduct?
Again, I don't know whether it's evidence, but it seems like something that Congress could ask about.
What about judicial assignment processes resulting in folks with apparent partisan bias being appointed or ending up administering a trial against such a target? Would that be such evidence?
I think that's a little bit of a conclusory question there, but certainly the process for determining judicial selections, appointments, I think that's something legitimately looked at.
How about contriving jury instructions or administering a trial to deny the target fundamental fairness and due process, anticipating that correction of that would be delayed until after the political impact has run its course in an election? Would that be evidence that Congress should be concerned about?
I think that's more a issue for appeal of the particular conviction. Again, respectfully, I feel there's a little bit of a conclusory aspect.
So you think so long as the appeal will eventually set things right, the fact that a state perverts its processes to achieve a political result to play out in an intervening election, that's okay. Congress shouldn't worry about that at all. Is that right?
I think the appeal needs to run its course first, and then if Congress has concerns about the case overall, they're free to look into it.
All right. I yield back.
And gentleman yields back. The gentlelady from the ranking member is recognized.